Welcome to the last panel of the day. My name is Christopher Schmidt. I teach here at Chicago-Kent College of Law, and I also am director of the Chicago-Kent Institute on the Supreme Court of the United States. It's my pleasure to introduce our panelists, I think all of whom have already been on stage today. So I'll just briefly go down the line to remind you who's up here, and then we'll jump into a preview of the upcoming term at the Supreme Court. So to my left, we have Jameson Jones of Bartlett Beck in Denver, Peter Manel, University of Berkeley Law, and then we have Constantine Trella of Sidley Austin in Chicago, Thomas Saunders, Wilmer Hale, DC, and Mark Perry, Gibson Dunn, also in DC. Did I get everyone? So the topic for our last panel will be a preview of upcoming cases. We'll have 3 topics we'll cover today. First, we'll look at the 3 IP cases that the Supreme Court has already granted to hear this upcoming term. We'll follow that by a brief discussion of cases that the court might be considering, some cert petitions we're going to be keeping an eye on that might be on deck for Supreme Court review this coming term. And then we'll open up to a general discussion about IP practice before the Supreme Court. So to start off, the cases granted. So far, the Supreme Court has granted certiorari in 3 IP cases. And we're going to start off. Thomas Saunders is going to discuss the 2 trademark cases the court has already accepted.
Yeah, I'm just going to give a very brief overview. The first is Hana Financial Inc. v. Hana Bank. This deals most directly with the relatively obscure doctrine of trademark tacking. The idea here is that when you're in a trademark dispute, priority of use is very important. And we don't want to have people sacrifice their rights in that respect if they're making very small adjustments to their trademark over time, refreshing it, maybe dropping an apostrophe, very minor changes. It's considered a very strict doctrine. You have a lot of cases out there that have taken changes and said, nope, that's too much, you've changed it, you've lost your ability to tack your rights back onto that earlier trademark. And so the standard that's developed over the years has said that you have to have such a degree of similarity that the 2 marks are, quote, legal equivalents. And that's a term we'll come back to. In this particular case, you had 2 financial institutions that were in particular pitching their services to the Korean American community. So you have some interesting questions relating to advertisements that were in English and Korean. But the question that's actually up before the Supreme Court is one of who should be the decider in this circumstance. In this case, the issue of whether tacking was permissible went to the jury. And so the case, when it comes back up and goes up to the Court of Appeals, there's an unwillingness to, or sort of recognition that there's change in the marks here. Maybe a court would have reached a different decision, but this was for the jury to decide. And in part, that's driven here by the Ninth Circuit saying, well, we recognize circuits take different approaches to the issue of likelihood of confusion in trademarks. Some talk about it as an issue of law. We here in the Ninth Circuit talk about it as an issue of fact. We think this is similar. It's not the same as likelihood of confusion, but we think that the same sort of issues come into play, and so therefore it's an issue of fact to go to the jury. Court granted review, I think, because of that division in the circuits. Just 2 things to watch for the case. One is, unlike a lot of the IP cases coming out of the federal circuit where they're coming out without a split, this is coming out more classically because of a circuit split, which makes it, I think, harder to predict which way the court's going to go because they may be granting just to resolve the split, not necessarily to reverse. And the other thing is when the case was first granted, because of that match between the circuit's approach to likelihood of confusion and to the issue of trademark tacking, I think a lot of people initially said, well, tacking doesn't actually come up that much, but likelihood of confusion comes up a lot, and so is the backdoor issue in this case going to be to hash out this divergence in approaches in the circuits and how they classify likelihood of confusion. I just offering my own views, it seems like the way the case is being argued, petitioner has filed its opening brief, tends to de-link those standards. There's a particular focus on if the standard is legal equivalence, that means it's a legal question of law, it's for the judge. And so a lot of emphasis on the particular aspects of tacking that might distinguish it from likelihood of confusion. So I think that we'll have to see what the court does, but the initial reaction that this might go beyond tacking, I'm not sure in the way the arguments are playing out that I would draw that conclusion at this point. Just jumping forward and keeping these brief, the second case of the term is B&B Hardware v. Hargis Industries. This case deals with the issue of preclusion doctrines and whether issues that have been litigated in the Trademark Trial and Appeal Board carry over to binding the court. In this circumstances, you had a attempted trademark registration that was opposed, and the really key question in that proceeding was likelihood of confusion. And so you have the Trademark Board ruling that there is a likelihood of confusion here, that then not being appealed, and B&B Hardware then having a trademark infringement, as the prevailing party in that circumstance, having a trademark infringement suit and saying, well, you've had your chance to litigate likelihood of confusion, you can't litigate that again in court. And in this case, the Eighth Circuit saying that no, issue preclusion didn't apply because there are various reasons offered, but it's largely focusing on the divergence in the standards that were applied in terms of everybody's applying these multi-factor tests, but the one that's being applied by the Trademark Trial and Appeal Board has different factors than the one that's being applied by the Eighth Circuit. And in the course of this discussion, too, it sheds a light on the fact that the Court of Appeals themselves are all over the place in terms of their own tests for likelihood of confusion, and led into debates of, well, why would you give preclusive effect to a decision coming out of one circuit when the test isn't quite different, but not do it for the Trademark Trial and Appeal Board? So this one's up before the Supreme Court, and I think the interesting thing here is whether the court just stays with the surface issue, which is the one of issue preclusion, or whether, because the nature of the argument is the differences in the tests, whether that causes the court to say things about the likelihood of confusion standard, or reconcile the tests in some way and say there may be different factors, but what everybody is getting at is X, that then could provide a more unified standard for the way people litigate these cases going forward.
Teva Pharmaceuticals versus Sandoz has already been briefed. Will be heard on October 15th. And it is, I feel, a very important case, although it operates at the case management level than at the substantive doctrinal level, which often attracts a lot of the media attention. But for patent litigators, I don't know that there has been a more important case. I guess eBay is very important in terms of how much clients will pay to have their case litigated. But in terms of how cases are litigated, Teva is really, it promises to be, I think, of great importance. And it's really deja vu of the Markman case. Markman was 2 decades ago, and it was trying to get at the problems that had emerged as litigators increasingly selected juries for their cases. And the whole issue of claim construction was put to the jury in a black box way. The Federal Circuit became concerned about that problem. It was hard for them to do their job in reviewing these cases. They didn't know how the Seventh Amendment was going to work out in terms of whether claim construction was something for the jury. And they issued an opinion in Markman 1, which solved the problem by saying that this is an issue of law, that claim construction is an issue of law, therefore the jury didn't get involved. Went up to the Supreme Court in Markman, And the Supreme Court came to a different approach, but the same result, that it is an issue for the court, but they didn't say it was a question of law. They said it was a matter for the court and did a very serious Seventh Amendment historical analysis. When it went back to the Federal Circuit held to the line that it is a question of law, even though the Supreme Court had called it a mongrel practice, mixed question of fact and law. And in the Vitronics case and in the Cyborg case, the Federal Circuit treated it as an issue of law subject to de novo review. Over the last 15 years since Cyborg, that has been a very controversial issue within the Federal Circuit. Members of the Federal Circuit have split year after year after year. District judges have complained vehemently that this is usurping their power, their ability to put together a record and to really learn the science and technology. And it resulted, at least initially, in a very high reversal rate. In empirical research that I've done with Jonas Anderson, we show that the reversal rate has really come down quite a bit, but as we explain it, it's not because the Federal Circuit is now finding the district judges getting the right answer. The Federal Circuit's losing interest. We call it a form of informal deference, but it produces the peculiar result that the Federal Circuit is reviewing cases involving these mixed questions without much of a record. District judges have feared writing much down because the Federal Circuit says that this is not an issue of fact that they use evidence for. So we sort of are still operating in a black box. It's a different black box than in the pre-Markman days. Last year, the Federal Circuit took a case en banc, the lighting ballast case, and I think people thought that the votes were there to finally reverse and alter the Cyborg de novo rule, and in a very surprising divided opinion, they ended up retaining it. But for a reason that the Federal Circuit has never acknowledged elsewhere, or at least in this jurisprudence, that stare decisis was the reason. And you got this very vehement dissent. While that case was while cert was being pursued in that case, the Supreme Court took the Teva case. And so we will get a direct, we think, a direct engagement with the question which the Markman case really punted on, which is whether it is merely a question for the court or a question of law. It goes to fundamental issues about how the judiciary functions. Do district courts have this special role in finding factual questions? I think, at least patent lawyers who I work with, all recognize that district judges often don't know the answers to the claim construction questions. They will often have tutorials. They will often use technical advisors. And it just seems in some ways pretty straightforward that there are factual elements in trying to determine what a person skilled in the art thought a term meant at the time that the case was, the patent was prosecuted. So it's an interesting lineup. What I'll say is that the strongest argument on the other side, or against reversing Cyborg, seems to be that a lot of the big tech companies do not trust district judges. And so there is this quality in their briefing that they would like a second bite at the apple. I think under fairly strict application of civil procedure, this should result in a reversal, but there is a political element of these cases. In some ways, maybe the case will boil down to whether the Supreme Court thinks the Eastern District of Texas or the Federal Circuit is the more renegade jurisdiction. And if you ask most district judges, they'll say it's the Federal Circuit. But at least there is some sense that maybe you need some additional supervisory authority. The argument that I think will win, at least the argument I made, and the Solicitor General has made a similar argument, and I think it's the right answer, is that the ultimate question is a mixed question, and the Federal Circuit will always get to review that because they'll get to read the prosecution history and the claim and the spec, and if the district judge diverges from those things, that's reversible. But there are subsidiary factual issues, like the one I mentioned earlier of what a skilled artisan would have thought a term meant at a time. And the other interesting feature, and since we have a lot of patent people in the room, this might generate some interesting discussion, is that it's not always that the terms in the patent claims are technical in a scientific or engineering sense. It's often that they're technical in a patent drafting sense. And I don't think that's something that either the Federal Circuit or the Supreme Court has really confronted. But we know that this is a highly specialized area. We know from the Nautilus case that there's going to be a lot more attention on claim drafting. And so there's, I think, a lot of interesting patent litigation material that the Supreme Court will address. And I do think that this case will have dramatic effects if they reverse in terms of trying to get a new procedure in place for claim construction. Judges will have a little more leeway to do evidentiary hearings and to build a record.
Terrific. So before we move on to the cert petitions, I'd just like to ask the remaining panelists if they have any thoughts on if any of these 3 IP cases which have been accepted for review have any particular interesting or significant components that we want to raise here.
Well, since I'm the newcomer to the panel,
yes.
I may as well jump in. So let me offer what I would call the layman's perspective on the Teva issue. I'm not an IP litigator. I'm a generalist appellate litigator. I have been involved, obviously, in some IP cases. But I remember when I first came to the question of how to construe patents and how to review that on appeal, I didn't know at that time much about how that worked, which I think makes me similarly situated to your average Supreme Court justice. And I think that for those of you who are patent experts, if you could take yourself back 20 years and put yourself in that perspective, what I sort of imagined at the outset, and the same thing was true with folks I talked to who didn't have this background, was here's the claim, here's the specifications, they're written in English. It essentially looks like a contract or any other written document. You read it and you figure out what it says. And so of course that's a question of law. It makes perfect sense. And I think that if you look at the bottom side briefs in this case, if you look at some of the briefing that was in Highmark and Octane last term, you get an attempt by the litigants to give that flavor to what's going on in claim construction. And so I think it's really important for litigants on the other side to do everything they can to educate judges to the fact that that is not what actually goes on the ground in a claim construction issue. And I thought actually I was reviewing the top side briefs from Teva in preparation for this panel, and I noticed that they did an excellent job of that. The statement of facts was longer than you would normally see in a Supreme Court brief, and it had graphs, and it had numbers, and it had exponents, and it had all kinds of stuff in it. And I thought that that was really strategically quite smart. It's sending this message to the court that what happened below was not legal interpretation. It was the gathering of facts.
Yes.
So the question was asked earlier, this increased interest, and Professor Monell mentioned that these cases work in some ways on the case management level rather than the doctrinal level. This is a Supreme Court that has interest from the Chief Justice on down in the nuts and bolts of civil litigation, of federal procedure and practice, in addition to doctrine and jurisprudence. And every one of these 3 cases is in part about the appropriate allocation of authority, decision-making and reviewing authority among the various stakeholders in the intellectual property system. You know, Hana is jury versus court. B&B is agency versus court. Teva is trial court versus appellate court. I mean, that's an oversimplification in each situation, but one of the things the Supreme Court has been doing, and this is not unique to IP law, this is what translates out from this space into the others, is statutes of limitations and discovery and tolling and the way that courts work to operate the disputes, that is, which is what courts do. This court has a renewed interest in, particularly as to those issues that affect multiple iterations of litigation in our federal court system. Some of them is just resolving circuit splits, and that's the court's traditional job. But some of it is sorting out and realigning things in a way. And I think that these cases are a good example of that. Again, on the Teva works on 2 levels, but on the structural level or case management level, these cases will provide a more stable framework, perhaps, as to how the relative participants in the litigation system, who decides first, and once that decision has been made, what deference or preclusion or whatever is given to it. That's important for litigants and appellate lawyers as well, because it sets the ground rules for what we get to do.
Before we move away from Teva, I have kind of one comment and perhaps more of a question from a generalist perspective. Reading this, I come away with the idea this is going to be a reversal because there are undeniably facts involved in claim construction that lead to kind of an ultimate question. I think it's likely the court takes the line that the SG does in terms of saying the ultimate question here as to what this claim means is legal. The real, whether or not Teva is an important case or merely a footnote, has to do with how the court decides and describes where that line is drawn. And ultimately, it may not give a lot of guidance in this opinion, and it'll take years to work out. Because you could say that the facts decided that are given clear error review are very, very narrow. In this case, whether molecular weight, it could be limited to things like, is molecular weight able to be calculated in multiple different ways? That's a fact that bears on the construction of this claim. Nobody disagrees with that. But how broadly you take the line that the SG is providing in terms of inferences from facts are legal as well will ultimately kind of determine how important the case is. And I would think they'd probably take that narrowly, that most of the questions involved are legal ones, but I'd be interested in kind of Professor Manel's or anyone else's view.
Well, in the Markman case, in the sort of critical passage, the court acknowledged that there could be credibility determinations. I mean, if scientists agree, and scientists often agree on highly technical terms, a lot of the Markman cases are about fairly ordinary terms and how they are interpreted within the context of the claim. And those may be words that we would recognize, but to a scientist, they might read it differently than we do. And that's part of the problem. A judge is more like a layperson, and there are only only one judge who I can think of, maybe two, who actually had a patent background before they got on the bench. It's very small. So for most judges, they feel at sea when they're dealing with these cases. But in the Markman case, the Supreme Court said they could imagine credibility issues coming up, but our own experience with document construction leaves us doubtful that trial courts will run into many cases like that. In the main, we expect any credibility determinations will be subsumed within the necessarily sophisticated analysis of the whole document. Now, what was the empirical basis for them to make that statement? None. They had not really looked at patent cases in the main, and it may be true that in statutory construction cases this is true, and maybe in contract interpretation cases, but people who spend a lot of time in the trenches of claim construction know that people often dispute these issues, and we've had tutorials, and we've had a lot. And so I think that when they look at this case coming 20 years later with a tremendous amount of briefing, I think they'll get the sense that patent cases perhaps are a little different, but that Rule 52A is the same rule that applies in these cases as well. And so I think they there's a good chance they will open up that pathway for district judges to make these findings, but I don't think it will be a sea change. It will just provide a little more light on what the district courts are already doing. And what it will do, though, is it will trim the Federal Circuit sails a bit. Because when a judge does a careful job and explains, then the Federal Circuit, as in, say, the Highmark case, is not going to have as much of the power that it once had. And I think that is a trend that we've seen in this uptick in patent Supreme Court litigation.
Well, I think how much it trims the Federal Circuit's sails will really get back to what Jameson was talking about, which I think is how narrowly or broadly the court defines what a factual issue really is. For example, the meaning that a term would have had to a person of ordinary skill at the time You could say it's a factual issue, but I think it's a legal issue because it is the ultimate claim construction question. So to call that a factual issue, I think, is wrong. And I know you disagree because I know that's because you had already described that as a factual issue. But I don't, and we'll see what the Supreme Court thinks. But it seems to me that if you don't conclude that that's a factual issue and that is in fact the ultimate legal question, I'm not sure the Federal Circuit sales are going to be trimmed much at all.
So if I can just briefly hear, so I don't disagree with the thrust of what you're saying. The difference that I was drawing is that the ultimate question is how you take what people think that answer is and they nest it within the patent claim and specification. So that's where you get the room for the Federal Circuit to come and say, no, they might have meant that, but they didn't write a claim that way, and they were their own lexicographer, or they made statements during prosecution history. And so the federal district judge is going to have to follow what the claim means unless there is no further explanation. And then I do think that they may want to have experts who disagree and make a judgment that this one's more believable than that one. So I do think the Federal Circuit will still have supervisory authority. But do you know the answer to what molecular weight meant to people in that art area?
Not a clue.
And I think that in many of those cases, when the judge pushes the lawyers and say, you really think you're going to have experts disagree about that? And then when the lawyers say, yes, we do, and they bring them on, then we'll have the battle of the experts. And that's something that district judges do all the time.
All right, I hate to cut this off, but we do have a few other points to move on to for this last session. So the next thing we're going to look at are the cert petitions to keep an eye on. So there's 5 IP petitions that have been filed, and we also added one more to discussion, which is the Sherlock Holmes case coming out of the 7th Circuit, in which there hasn't been a petition filed, but likely it will be soon. These materials are summarized in your packet on page 134. So we're not going to actually walk through and summarize them right now, but I do want to throw out a question to our panelists, and that is, looking at these, the 6 cases in which the court might be considering, are there any in particular that you really would like the court to take up?
I'll start. I would love to see the court take up the Cisco case, the one raising the 7th Amendment issue, in part because that's been a pet issue of mine for years, but also in part because I think that one has potential implications far beyond just IP law. The Supreme Court had a decision, I think in the 40s, gasoline products, which basically said that you can't remand for a new trial on a limited factual issue if that factual issue is intertwined with other factual issues that the first jury already decided, that you have to have, that violates the 7th Amendment, that factual determinations by a jury shall only be reviewed as they were at common law or whatever, and it would put the second jury in the position of second guessing the first jury. That decision actually, if you really read it and apply it literally, has significant implications for how cases are handled after a remand. Judge O'Malley, in fact, had a discussion in her separate opinion in the Bosch case, the Bank case, where she talked about gasoline products, and I think largely, I think the appellate courts, they're well aware of gasoline products. I think they ignore it because they don't like the implications of it, because it can make retrials much more complicated. But we also, there was I'm going to blank on the name of the case, but there was a Federal Circuit case where there was a dissent. An obviousness finding was sent back for a retrial on one of the obviousness factors. I think it was secondary considerations. And that, I think, is something that under gasoline products just doesn't make any sense. You've got a series of factors that a jury is supposed to consider. You have one jury deciding some of them, one jury deciding others. And that, I think, is an issue raised in the Cisco case that I think could be very significant.
Any other thoughts? Cases that I'd like to see?
On this list, not really.
Good.
I agree with that Cisco case, which Tom's firm is handling. It's got some quirks. It's a conditional cross petition, and there's a sort of funny predicate question. And But I agree with this. The Federal Circuit, one of the problems we have with the specialized court is they have not seen the Seventh Amendment cases and issues arise and the counterpart issues under the Sixth Amendment the way the regional circuits do. And I think it's fair to say that the treatment, or usually the lack of treatment, that the Federal Circuit has given the Seventh Amendment is troubling in many circumstances and does raise very serious issues. And I wouldn't be surprised to see a Seventh Amendment question come up out of the Federal Circuit. Whether it's this case, I don't know enough about it other than it's got quirks in it, but it is certainly a recurring issue in some of these, because there's lots of remands. I mean, part of the high reversal rate means these aren't total reversals, they're reversals for more proceedings. And so you're bouncing cases back and forth. We've all had these cases. They go to the district court, they go up to the Federal Circuit, they go back to the district court, and pieces of them, sometimes they go to final judgment, sometimes they don't. And that is an issue, and it obviously has intersections with some of these other cases we've been talking about. If it's assigned to the jury as a question of fact and so forth, that then has Seventh Amendment implications as well. So that, there's a convergence there that is sort of lurking in the background that will have to come to light at some point. I just don't know when.
So moving on to our third topic for today, and that would be just a general discussion of Supreme Court IP practice. I'd love to raise a question that arose in Dave Short's and Ed Lee's presentation, the last presentation, and looking at the rise of cases, IP cases, the Supreme Court's actually been hearing recently. I was wondering if we have any thoughts about why we see this uptick.
The court is more interested in business cases these days, the ones of importance. I mean, people speculate that Chief Justice Roberts is driving some of that. I think some of the public opinion that there is a crisis with respect to patent trolls and in the patent system is driving some of that. And the Supreme Court thinks that the Federal Circuit's kind of gone off the rails in a lot of ways, and that it's been trying to rein them in. And I think it's a combination of a lot of those things.
I'm going to second most that opinion. I don't know that there's that big an uptick in copyright and trademark. There's definitely an uptick in patent. And there is this really interesting dialogue among the institutions, the Congress, Federal Circuit, and the Supreme Court. And I see the courts in some ways trying to fill in some gaps, recognizing that Congress is struggling to deal with these issues. When you go back to about 12 years ago to the reform proposals, you look at what the National Academy of Sciences and what the Federal Trade Commission had reported in their comprehensive studies, and then go to the 2004 draft legislation. There were about 10 issues that were in that draft. And if you look at what the AIA produced, it only dealt with maybe half of those issues. The other issues were all dealt with by the Supreme Court or the Federal Circuit, that one by one, each year after year, we saw. And so the Supreme Court, which had largely ignored the patent area, has now engaged. They no longer fear these cases as much. They feel a responsibility. And I think that will continue until, the beatings will continue until people behave. I mean, it's going to continue until this sense of the patent system being out of control is resolved. I think a lot of what has happened in the last few years is resolving the issues, in the sense that there were a lot of patents out there due to the .com era, and the better of those have been asserted and have resulted in some of the litigation that we've seen. But the Patent Office has really cut back in the last year on what's going to come out from there. And there's still enough mischief out there that we'll see patent cases. I can't really speak to the copyright or trademark area as having a systematic source.
So let me just refine the question. If there's any more thoughts on the rise, particularly patent cases or IP cases generally, and then also thoughts on Professor Mello's point that this actually could just be a temporary, certainly with the patents, that if there are in fact problems that the Supreme Court's dealing with, is this going to be a temporary rise, and then maybe at some future point we're going to see it revert back to historic norms?
Well, sure. I mean, I think that, if you look at the run of cases the Supreme Court hears in almost any area, you see these strange surges, right? Suddenly there'll be double the number of criminal cases that they usually take, or double the number of whatever, dormant commerce clause cases. And then after 5 years or so, when all of the ripple effects of the decisions and further decisions on remand and et cetera are ironed out, it falls back to normal levels, and I don't see any reason why it would be different in this space.
I disagree with that. I think we are watching a transformation of the economy into, we have already watched the transformation of the economy into an information-based, technological-based environment in which patents, and to a lesser extent trademarks and copyrights, have an absolutely central role, and the stakes are so high that an area of the law that used to be dealt with by subject matter experts at small, specialized boutique firms, often regional firms, handled by a specialized court. It might have made sense in 1982. It doesn't exist today. I mean, look at the law firms that are sitting at this table. Look at the work that's being done in the space. These are multi-million, multi-billion-dollar cases that we're litigating. The consequence, the downstream consequences for commerce and the economy are huge. The stakes are so high. Congress has written into the law, the Hatch-Waxman Act, for example, guarantees litigation and makes it almost impossible to settle. So we've got in the biotech area constant litigation as part of the business model. The smartphone wars that Davis Cap has talked about. There are other entrenched industries where they are cross-licensed or not cross-licensed portfolios, and they're at each other hammer and tong. There is so much value in the portfolios and so much in economic incentive to sue, and then the NPE, scenario is a whole different thing. But even just head-to-head competition, I don't think that will abate as long as we have strong intellectual property protection, which I don't hear anybody today advocating anything other than that. If you have property rights, people will debate them, and those property rights have become more valuable or more important or more litigious. So some of this will simmer down, I suspect, but I think we're in a world, the reason the whole litigation has transformed into much bigger cases, much more expensive cases, is there's just more at stake. And I think that probably is going to stay the case. I don't know that, but I suspect it's true.
Well, we're all reading tea leaves, of course, but I guess I don't disagree with what you're saying as far as prospects for continued high levels of IP litigation in general. The question of whether it will get to the Supreme Court and the numbers it's been getting to is a different one, I think.
That's true.
And if the Supreme Court starts to get the sense that they've ironed out the major doctrinal wrinkles and the Federal Circuit is back on track, which you would think sooner or later, as you say, if the beatings continue long enough, will happen, I would expect that there will be a drop-off. I can't imagine that the number of patent cases that are going to the court over the last couple of terms is going to be a permanent trend, but maybe I will be proven wrong.
So Dave and Ed in their presentation emphasized two characteristics of last term's IP cases in the Supreme Court that made them stand out somewhat. One is a high level of consensus among the justices on these cases. It was a term that was characterized by high levels of consensus, but it does seem like the IP cases in particular went above and beyond in that regard. And also the high rates of reversals. So I was wondering if I had the panelists comment on whether they think any thoughts on the significance of either of those two characteristics?
Well, I think, and I don't remember whether it was Professor Lee or Professor Schwartz, I think gave a good explanation for the high level of reversals, at least in the patent cases, and that is you don't have splits among the circuits, so that reason for granting cert isn't there. So leaving the main reason that they think the Federal Circuit screwed something up. So I think you would expect to see a high rate of reversals there. On the unanimity, I have a theory which I'm sure probably everybody will disagree with, but I think that notwithstanding what Mark and others have said about the increased interest in this area of the law on the part of the court, and I think there is an increased interest, I think that there are only 2 or 3 justices who really care about this area in the sense that they're willing to really dig into it. And so they tend to drive these cases, and the others, they're sort of along for the ride. Nobody feels strongly enough or digs into it enough to really disagree with them. So, that's my own personal theory, explanation for the unanimity.
Well, I'll supplement that with one point, and this is just drawn from my particular experience last term with Highmark and Octane. I think another reason for the unanimity, at least with respect to those cases, is that the Federal Circuit was just quite clearly wrong. And that goes back to Connie's point, which is that, in a Federal Circuit case, sometimes you can assert a split, but often you cannot because of the nature of the Federal Circuit. And so if it comes up, it tends to be more of an error correction situation. But in this recent environment, and all these questions kind of play into each other, in this recent environment where there's a sense that the Supreme Court has felt that the Federal Circuit has gone astray, I think they have been taking cases where, at least that's certainly what the topside briefs are arguing. And a lot of times the Supreme Court appears to have taken them because it agrees with that proposition and reverses without a lot of difficulty.
And just to add to that, if part of the idea of taking these cases is to send the message to the Federal Circuit that the rules that apply to regular litigation apply to patent litigation as well, in the same way, even if some justices might otherwise be tempted to have separate writings, I think the idea of unanimity in sending that message probably decreases the number of separate writings that you might see.
And the other trend, beyond just saying the general rules apply, you're seeing the Supreme Court going for flexible standards. And so I think it's much easier to get to 9 votes in the attorney's fees cases when you end up with essentially totality of the circumstances. Or in Alice Corp, whereas we're seeing on the panel, everybody's looking at this and saying, well, what does this actually mean in practice? Or in Nautilus, where you're essentially just stating this should be reasonably ascertainable. So I think that when you have decisions that leave so many unanswered questions, it's easy to get to unanimity on that standard. And although that is the Supreme Court reversing the Federal Circuit time and time again, you do wonder, I think the Supreme Court must realize that when it leaves it that open, as a practical matter, that is putting a lot of this authority back in the hands of the Federal Circuit, because it's going to be the one that's monitoring the application of those standards in the mine run of cases.
There's an interesting deja vu to the 1940s in which Justice Douglas and some other members of the court could never seem to find a patent that they thought was worth the paper it was written on. There were some interesting, some amusing comments made by members of the court at that time about that skepticism. I think that the software and business method patents have reignited that skepticism. And so you might see some additional litigation at the Supreme Court level if the Federal Circuit is unable to come to any resolution. Like, I thought the Alice case was a really bad case for the court to take. It wasn't really that different from Bilski. It was not going to be a good vehicle. But when the Federal Circuit divides 5-5 with multiple opinions, and then, even Chief Judge Rader put up a white flag. I mean, he basically, did this mea culpa. I failed as a chief judge because of a decision this bad. So I think they took that in some ways because the buck had to stop somewhere. I do think we do need another case or two, and Becky Eisenberg, I think, highlighted it well. We need to see some cases on the other side of this divide in order to know whether the word machine has any meaning in Section 101.
Just a quick follow-up. So Mr. Trella suggested that there's only a couple of 2 or 3 justices on the court who are really driving the ship on many of these cases. I was wondering, does that affect how, if we agree with that, and does that affect how you write or argue before the court? Because in areas of constitutional law, we have, of course, the Kennedy brief, right? People are all writing for Justice Kennedy because he's seen as a swing vote. Does that affect how you approach some of your arguments before the court?
I think it does. I think if you're writing in an IP case, and I'd actually be interested in what others think, but I think you're thinking about the Chief Justice, for example. You're thinking about Justice Breyer. You're probably thinking about Justice Kennedy. It's not that you're ignoring the others, but I would view them as votes that you're writing to get on the theory that they will, to some extent, they're driving the ship.
I mean, one thing that's interesting to me about the 9-0 opinions, and this maps onto the case assignment process of the current Chief Justice, is that the current Chief believes a lot in rotating case assignments, so you don't necessarily see the same people always writing in the same area of the law. And when you map that together with 9-0 decisions where everyone agrees on the vague outcome, I think it can be a little hard because you can have just swings based on the randomness of the assignment process. Where I see it really coming in is not so much in the way it's pitched in the briefs then, but in the oral argument preparation, in the sense that you know, if you are representing the patent owner, for example, that you expect active questioning from Justice Breyer, and you have a sense of what his concerns are, and trying to navigate that in oral argument while still having enough time to talk to the people who you think may be more in the middle.
To say, I found Justice Kagan's questioning and Justice Sotomayor's questioning in the transcripts to be really interesting. I see them both as really trying to problem solve in these cases. And perhaps because they're newer, they don't feel as bound by the older decisions, but they're often really seeing if there is, some better solution as opposed to being, being committed to one outcome.
All right, we do have time for a couple questions from the audience, if there are any. So would anyone like to ask a question for our panel?
There were some discussions between Mr. Perella and Mr. Perry regarding the number of cases that you believe is going to go to the Supreme Court and whether that trend that we're seeing now is actually going to increase. With the advent of the inter-parties review under the AIA, do you still feel that that we're going to see increased numbers of cases or no increase at all?
Well, that leads to a further empirical question that I actually scribbled a note when Ed was up there. In part, and this is, Don made this point, in part the number of cases that the Supreme Court sees is a function of the number of cases the Federal Circuit decides. That number has been expanding a little bit, but not nearly as dramatically as the Supreme Court had. It would be interesting to track over time the Federal Circuit's, not only its decisions, but its divided decisions, because the Federal Circuit is fractured today in a way that it wasn't, 10 years ago. Therefore, that's one driver. The inter-parties review and the other procedural devices in the American Invents Act, the CBM process and so forth, will sideline some cases. There's an exit ramp there for some cases. They will not, however, eliminate the sort of high-stakes patent litigation that has led to, I believe, all of the Supreme Court cases this term. I mean, in other words, it will affect some cases, but there will still be these kinds of cases where there are significant stakes that are going to be litigated in district court, for strategic reasons. So I think it will have an effect. It'll have an effect on the 101 area in particular, but it's not going to dramatically change, I wouldn't guess, the number of cases decided by the Federal Circuit, which is the real driver to the Supreme Court. In a patent case, that's the only way you can get there. You've got to go through the Federal Circuit first.
And I'll actually say that sort of 4 to 5 years out, I actually think that the IPR process is going to lead to a short-term increase in cases, much as we see sort of any time there's a new federal statute, because you see people litigating use of broadest reasonable construction. There are issues that are filtering up about estoppel and what happens when the office institutes on some of your claims but not others. So I think that you end up with a lot of who decides and procedural questions of the type that Mark was talking about earlier that will bubble up through the system and actually be something that, if it seems important enough, the Supreme Court will think, well, these are sort of general questions that we could actually address, particularly if they think the Federal Circuit has done something strange in those areas.
Well, with that, we're out of time, so please join me in thanking our panelists for a wonderful conclusion to the day.
Okay, so we're at the end of our program, and I just wanted to say a few thank yous to people without whom we could have not, we could not have put on this conference, including, of course, first of all, our sponsors who are listed on your program, the speakers, all the speakers who came and traveled from various parts of the United States. I thought today's program was incredibly informative and enlightening, and I hope you did it as well. I'd like to also thank all of the student helpers who kept time and who worked the registration desk. And I also would like to thank Jared Steimer back there running the camera, and Sue Jaden and all the AV people. It's amazing to me when you can have a conference where there are no technology problems. So this was probably the first conference that I hosted where there were 0 problems, even though we had to Skype in 2 people. So thanks a lot, Jared, and your team. I'd like to thank Patricia O'Neill, who worked behind the scenes on logistics for many of the parts of putting on this conference, including last night's dinner for the speakers. I'd also like to thank our IP fellows, Patrick Gould and Joy Shang, who are sitting back there, who also helped out in numerous ways. And then finally, I would like to thank all of you, our audience, who came in and sat for an entire day listening about 10 Supreme Court cases involving IP. I hope that you enjoyed this conference as much as I did, and I look forward to seeing you all back here next year. And with that, I will adjourn our conference. Okay. Thank you.